She didn't hug me at my grandmother's funeral. She stood on the other side of the casket, watching me the way you watch someone you're about to sue. 3 weeks later, I found out that's exactly what she was planning to do. My Aunt Patricia had been wealthy for most of my adult life, not self-made wealthy, but married into it wealthy, which in her mind was somehow better. She drove a car that cost more than my annual salary, lived in a house with a name instead of an address, and had developed over the years a particular way of looking at people who had less than her. A kind of patient, almost clinical assessment, like she was calculating what you were worth and whether it was enough to bother with. She had never looked at me that way, until my grandmother died. My grandmother, Dorothy, was 81 years old when she passed. She had lived alone in the same house in Columbus, Ohio for 43 years. It was not a grand house. 3 bedrooms, a screened porch, a kitchen that always smelled like coffee and something baking. She had raised my mother and Aunt Patricia in that house. She had babysat me there every summer until I was old enough to stay home alone. I knew every creak in that floor, every draft from that back window, every stain on that carpet that came with its own story. Grandmother Dorothy had updated her will 8 months before she died. She left the house to me. She also left me a brokerage account she had quietly built over 30 years index funds, patient and steady, the way she did everything. Combined, it came to just under $400,000. Aunt Patricia received a pearl necklace and a handwritten letter. I did not know about any of this until the will was read. I sat in the attorney's office with my hands folded in my lap, and when the executor finished reading, I couldn't speak for a moment. I thought there had been a mistake. I looked at my mother, who was crying softly. I looked at Aunt Patricia. She was not crying. She was very, very still. That was a Tuesday. By Friday, I had been served. The petition alleged 3 things. First, that Dorothy lacked testamentary capacity at the time she signed the updated will due to cognitive decline. Second, that I had exerted undue influence over Dorothy, isolating her from family and manipulating her into changing her estate plan. Third, that certain assets in the brokerage account had been improperly transferred and should be considered contested property subject to court review. I read the document twice, sitting on my kitchen floor, still in my coat. My grandmother had taught me to play chess when I was 7. She was the kind of woman who always thought 4 moves ahead and never once told you she was doing it. She made decisions quietly and she made them completely. She did not make mistakes with paperwork. I called a probate attorney that same evening. His name was Marcus Okafor, and he had been recommended to me by a colleague who had gone through something similar with a step-parent's estate 2 years prior. He listened to everything I told him without interrupting. When I finished, he was quiet for a moment. Then he said, "Did your grandmother ever put anything in writing about her intentions? Anything beyond the will itself?" I told him what I had. He told me not to discuss it with anyone. The months between the filing and the court date were some of the strangest of my life. Aunt Patricia's attorney sent discovery requests that felt less like legal procedure and more like an inventory of every interaction I had ever had with my grandmother. How often did I visit? Did I accompany her to doctor's appointments? Had I ever helped manage her finances? Did I have access to her accounts? Did I have a key to her house? Yes, to all of it. I had been close to my grandmother. I had driven her to appointments when her vision made her nervous about highways. I had helped her set up online banking because the branch near her house had closed. I had a key because she asked me to have one, after she fell getting out of the bathtub 2 years before she died and lay on the floor for 4 hours before a neighbor happened to call. Aunt Patricia had visited Dorothy 11 times in the last 5 years of her life. I had kept every card my grandmother ever sent me, and Dorothy had mentioned each of those visits. I knew the number because my grandmother mentioned, each time, that she hadn't expected to see Patricia and was pleasantly surprised. 11 times in 5 years. I did not say any of this out loud, to anyone except my attorney. My attorney told me to let him handle the discovery responses. He told me to keep showing up to work, to keep my routine, and to stop reading Aunt Patricia's social media, which I had been doing obsessively at 2 a.m. for weeks. He also told me that what I had was significant. What I had was this: a notarized letter, written in my grandmother's handwriting and witnessed by a notary public and 2 people unconnected to our family, dated the same day she signed the updated will. In it, Dorothy explained, in her own words, exactly why she had made the choices she made. She explained her relationship with each of her grandchildren. She explained that she had consulted with her attorney, her own attorney, not mine, 3 times before finalizing her decisions. She explained that she was aware her choices might cause conflict and that she had made them anyway, because they were hers to make. She also enclosed, with that letter, a document that Patricia's attorney had apparently forgotten existed. 2 years before Dorothy died, Patricia had asked her to sign a quitclaim deed transferring the Columbus house directly into Patricia's name. Dorothy had declined. The document with Patricia's attorney's letterhead and Dorothy's handwritten refusal written across the signature line had been sitting in Dorothy's fireproof lockbox ever since. Dorothy had given it to me 18 months before she passed. She handed it to me over coffee on a Tuesday morning, slid it across the kitchen table in an envelope, and said, "Put that somewhere safe. I have a feeling you might need it someday." I had not understood what she meant. I do now. The hearing was held on a Wednesday in February. The courtroom was smaller than I expected. Wood-paneled, fluorescent in a way that made everyone look slightly unwell. I arrived early with Mr. Okafor. Aunt Patricia arrived with her husband Gerald and a younger man who turned out to be a second attorney they had retained, specifically for the medical incompetency argument. Patricia wore charcoal gray. She sat with perfect posture and did not look at me. The judge was a woman named Judge Carol Whitmore. She was in her late 50s, I guessed. With reading glasses she wore low on her nose, and a manner that was precise and patient in a way that felt, somehow, more intimidating than severity would have been. She spoke to both attorneys before the session formally began, briefly, about procedure and timelines and the scope of what she intended to cover that day. Then she looked at the room, and the room got quieter. Aunt Patricia's lead attorney, a man named Hargrove, opened with the incompetency argument. He presented an affidavit from a physician who had evaluated Dorothy's medical records and concluded that her documented cognitive decline in the final year of her life raised significant questions about her capacity at the time of signing. He used words like diminished executive function and susceptibility to influence. He spoke with confidence and at length. Judge Whitmore let him finish. Then she looked at the physician's affidavit for a moment and said, "Counsel, was this evaluation conducted in person?" Hargrove said, "It was a records review, Your Honor. The physician never examined Mrs. Dorothy in person? The examination was conducted through her medical records. Yes." Judge Whitmore wrote something down. "And when was this review conducted?" "It was completed last September, Your Honor." 7 months after your client filed this petition? It was not a question. Hargrove said, "That's correct." Judge Whitmore looked at him for a moment over her glasses. "Continue," she said. Mr. Okafor presented our response to the incompetency argument. We had our own physician, one who had actually treated Dorothy in the last 2 years of her life, who submitted a sworn affidavit attesting to Dorothy's orientation, her recall, her capacity for complex decisions, and the specific office visit at which Dorothy had informed her doctor that she was updating her estate planning and understood the implications. Dorothy had asked her doctor to note it in her file. The doctor had. The note was dated 6 weeks before Dorothy signed the will. Patricia's second attorney stood briefly to object to the relevance of the treating physician's testimony versus the specialist review. Judge Whitmore overruled him without looking up. Then Hargrove moved to the undue influence claim. This was where his confidence returned. He argued that I had systematically isolated Dorothy from her family, inserting myself into her medical care and financial management in ways that gave me disproportionate influence over an elderly woman. He cited my name on her emergency contact form. He cited my presence at 3 of her last 5 medical appointments. He cited the fact that I had helped her set up online account access and that my email address was listed as a secondary contact on one of her financial accounts. He called it a pattern of calculated access. I sat very still. Mr. Okafor let him finish. Then Okafor asked the court's permission to submit an exhibit and walked to the clerk's table and handed over the sealed envelope my grandmother had given me. Inside was the notarized letter. Inside was the quitclaim deed with Patricia's attorney's letterhead and Dorothy's refusal written across the bottom. The clerk read the notarized letter into the record. I watched Patricia's face as Dorothy's words filled that fluorescent room. The letter was written in the voice I knew, deliberate, warm, completely unambiguous. Dorothy explained that she had chosen to give me the house because I had been present in her life, and that she did not believe presence should be weaponized as manipulation. She wrote that she understood some members of her family would be disappointed. She wrote that she had made her decision with full awareness of that disappointment and had chosen to make it anyway. She wrote, near the end, that she hoped the people who contested her wishes would ask themselves, honestly, how many Tuesday mornings they had spent at her kitchen table. Gerald shifted in his seat. Patricia did not move. Then the clerk read the quitclaim deed. Judge Whitmore picked up the document and read it herself, slowly. Then she set it down and looked at Hargrove. "Counsel, she said. Your client's name appears on this document as the requesting party. Yes, Your Honor. This document requests a transfer of the property that is now the subject of this petition to your client, 2 years before the decedent's death. Yes, Your Honor. And your client's current argument is that the decedent lacked the capacity to make informed decisions about that same property. The room was quiet. Hargrove said, "Those are two separate." "I'm not finished," Judge Whitmore said. Her voice didn't rise. It didn't need to. Your client approached the decedent and requested transfer of a significant asset. The decedent declined. Your client now argues the decedent was incapable of sound judgment. Do you see my difficulty with that sequence? Hargrove opened his mouth, closed it. If the decedent lacked capacity, Judge Whitmore continued, then the refusal documented here is also a product of that incapacity, and your client's prior claim to the property evaporates entirely. If the decedent had capacity, then the refusal was valid and so was the will. Counsel, which argument would you like to make? The second attorney leaned over and said something quietly to Hargrove. Hargrove nodded once, slowly, like a man absorbing a loss he hadn't yet decided how to name. Judge Whitmore turned to Patricia directly. This part I did not expect. Ma'am, she said, I want to ask you something directly, and I want to be clear that your attorney may object if he believes it's inappropriate, but I want to give you the opportunity to speak to the record. Patricia looked up. Were you present when this quitclaim deed request was made to the decedent? Patricia glanced at Hargrove. Hargrove gave the smallest possible nod. Yes, Patricia said. I was present. And you understood at that time that the decedent was declining the request? A pause. Yes. Did you seek any other legal remedy at that time? Any challenge to her capacity? Another pause. Longer? No. Why not? The silence that followed was the specific silence of someone realizing they have walked into a room with no other exit. Patricia said, quietly. She seemed fine at the time. Judge Whitmore wrote something in her notes. She wrote for what felt like a full minute. The scratch of her pen was the only sound in the room. She seemed fine, Judge Whitmore repeated, without looking up. Thank you. Hargrove called one more witness, a distant cousin, who testified that Dorothy had seemed confused at a family birthday party 18 months before her death. Under cross-examination from Mr. Okafor, the cousin acknowledged she had spoken to Dorothy for approximately 12 minutes at that party. She acknowledged Dorothy had asked her to repeat something she said once. She acknowledged that she had not spoken to Dorothy again after that party. She acknowledged she had spoken to Aunt Patricia's attorney 3 times in the past 2 months. Mr. Okafor did not belabor the point. He simply thanked her and sat down. When it was our turn to present, Mr. Okafor called Dorothy's estate attorney as a witness, the attorney who had drafted the will, who had met with Dorothy 3 times, over 6 weeks before the signing, who had documented her own assessment of Dorothy's competency as part of standard practice. The attorney testified that Dorothy had arrived at each meeting alone, that she had asked precise questions, that she had requested specific language changes, that she had brought a handwritten list of questions to the second meeting and worked through each one methodically. She testified that in 30 years of estate planning practice, Dorothy was among the most deliberate clients she had ever worked with. Hargrove's cross-examination was brief and produced nothing useful. Then Mr. Okafor submitted the last piece of documentation, an itemized log I had kept, without knowing why exactly, of every visit I had made to Dorothy over the last 4 years of her life. Date, duration, purpose. I had started it almost accidentally when I began driving her to medical appointments and needed to track mileage for my own records. It became a habit. Every Tuesday morning, if I visited, I logged it. Every prescription pickup, every grocery run, every afternoon I spent just sitting with her because she liked company and I liked being there. 212 visits in 4 years. Hargrove looked at the document for a long moment. He did not try to contest it. Judge Whitmore took a short recess after our presentation. When she returned, she did not deliberate. She had been deliberating during testimony. I realized those notes she kept making, that quiet attention, the questions she asked that seemed conversational but weren't. She denied the petition in full. She found that Dorothy had demonstrated testamentary capacity, supported by the treating physician's records, the estate attorney's documentation, and the notarized letter. She found that the evidence did not support a claim of undue influence. She found, further, that the submission of a records-only psychiatric review, conducted after the filing of the petition, without any contemporaneous evidence of incapacity, did not meet the legal standard for contesting the will. Then she said something else. She said that the court had reviewed the quitclaim deed and found it relevant not only as evidence of Dorothy's capacity, but as potential evidence of prior intent to acquire the same assets now being contested through litigation. She said she was referring the matter to the State Bar's disciplinary office for review of whether the petition had been filed in bad faith, and whether counsel had an obligation to disclose the deed before filing. She said she was making no findings on that question today, but that the referral was appropriate given what the record showed. Hargrove went very pale. Gerald put his hand over Patricia's hand on the table. She did not respond to it. The clerk read the final orders. The estate would be administered as written. All legal fees incurred by the estate in defending the petition would be assessed against the petitioner. The petition was dismissed with prejudice. I sat very still while Mr. Okafor made notes, and the clerk gathered papers, and the room slowly emptied. Patricia stood. She smoothed her jacket. She picked up her bag. She walked toward the door, and she passed within 4 feet of me, and she did not look at me. Not the way you avoid looking at someone you've lost to. The way you avoid looking at something that has stopped being relevant. I watched her go. Then I sat there a little longer, in that fluorescent room that smelled like old carpet and paperwork, and I thought about Tuesday mornings. I thought about the coffee she made too strong and never apologized for. The way she kept a bowl of wrapped candies on the kitchen counter, even though she never ate them herself. Just for visitors. The chessboard she kept on the sideboard even after her hands got stiff and she couldn't hold the pieces the way she used to. The Tuesday she slid that envelope across the table and said, with complete calm, "Put that somewhere safe. I have a feeling you might need it someday." 4 moves ahead, patient and steady, the way she did everything. My grandmother was a woman who made decisions completely and quietly, and she had made this one with full knowledge of what it would cost me to carry it. She had prepared for the fight before the fight existed. She had handed me what I needed and trusted me to hold it without knowing why. I had held it for 18 months. Outside, Mr. Okafor walked with me to the parking lot. The February air was sharp and honest. He told me that the bar referral was meaningful, that it would create a record. He told me the fee assessment was likely to be significant. He told me I had done everything right. I thanked him. I meant it. I drove home on the highway Dorothy had been nervous about near the end. I passed the exit for her street. I didn't take it, because the house is mine now, and I have not yet figured out what to do with that, what it means to inherit the place where someone you loved became the person you loved, what it means to walk through those rooms now that the person who filled them is gone. I know what I will not do. I will not sell it quickly, out of grief or guilt or any misplaced desire to make the inheritance disappear so that having it doesn't feel like losing her. She gave it to me because she wanted me to have it. She thought 4 moves ahead and she made her decision completely, and she would not be patient with me for treating her gift like a burden. I have the chessboard. I took it the week after the funeral, before any of this started. It's on my sideboard now. The pieces are the same ones she taught me on when I was 7. She always said the point of chess wasn't to win. It was to understand, completely, what the board actually looked like, not what you wished it looked like, not what your opponent wanted you to think it looked like. Just the truth of it, square by square. She had looked at her board completely, and she had left me every piece I needed.